The chair recognizes the gentleman from Texas, Mr. Poe, for 5 minutes.
Thank you, Chairman. Thank you for being here. Just so it's clear, I'm one of the numerous members of the Judiciary Committee that have asked for a second special prosecutor based on what Mr. Jordan earlier said. The Justice Department is responsible for investigating criminal conduct. Would that include criminal conduct by the NSA?
Yes.
Okay. We all learned under the prison that was happening years ago by the NSA that the NSA was doing, in my opinion, unconstitutional surveillance on Americans and their emails by tracking it and hacking in to see those emails. Came to light under Snowden, after Snowden, who I care nothing for, brought that to America's attention. The NSA said, we're not going to do that anymore, which I think is appropriate because I thought it was unconstitutional. And we've heard reports through the media that there has been unmasking of information. What I mean by that is classified information is seized on somebody, and someone else, an American, that their name is caught up in the communication, and if someone leaks who that was, unmask that individual, my understanding is if it's classified information, whoever does that unmasking has committed a felony. Is that correct?
The only distinction I would make, Congressman, is the unmasking typically is something done in the course of the intelligence analysis. The leaking would be a violation.
That's what I'm talking about, the leaking of that information. And as of today, has anybody been indicted under PRISM? Has anybody been indicted under leaking information on unmasking up until today? Has the Justice Department indicted anybody under those two scenarios and events?
We have indicted, prosecuted people for leaking. I'm not certain whether, I don't believe any of them related to unmasking.
So no one's been indicted, to your knowledge, which I want to bring up now the Foreign Intelligence Surveillance Act that has been discussed by this committee numerous times. It's the law that allows secret courts to issue secret warrants to try to go get terrorists that are operating overseas and get their information. Does the Justice Department present those FISA warrants to a FISA judge?
In situations where a warrant is required, yes, it needs to be obtained from a federal judge.
That's right. But the Justice Department is responsible for that. Is that correct?
That's correct.
Also under FISA, once again, Americans are brought into the scenario because you target a foreign terrorist and then you go after their emails and then you find emails of Americans, and those are inadvertently caught in the surveillance of the target. According to the Washington Post recently, 90% of those inadvertent emails are on Americans. And my question to you is, why hasn't the Justice Department, the FBI, the intelligence community presented to Congress and our request that took place years ago, how many of those inadvertent emails, communications, text messages, conversations have been on Americans? We have been asked for the number. Do you know why that has not been brought to our attention? And let me just follow up with this reason. Here's the reason we need it. We're getting ready to maybe reauthorize 702, which I have a lot of problems with. I think it's unconstitutional in many other ways. But beside the point, here we are at a deadline getting ready to reauthorize it, and still the intelligence community refuses to tell us how many Americans' information has been seized. Can you tell us why we haven't gotten that information that we've asked for years?
No, I testified at a hearing with Director Coates, who I think would be a more appropriate person to answer that because he has access to the data and he has explained it. But I would simply point out that you use the term inadvertent. I think the term that we use is incidental. If you're,
Incidental, I don't mind the problem, the name of the
my
change.
point is simply if you're investigating a foreign terrorist, knowing with whom that person is communicating may be relevant to your investigation. And so it's not.
That's not my question. My question was, we're getting ready to maybe reauthorize 702. I don't think we ought to reauthorize it until we find out from the intelligence community where there are no indictments that have been issued against the intelligence community based upon the statements that you have made to see whether or not they're violating the law, and they refuse to give this committee the information about how many people have been caught up in that. And it's been stonewalled by the intelligence community saying, well, we just can't do it. Why can't the intelligence community get some geek over at Best Buy and have them come in and answer that question with a few little taps into the big computer system? We just want the number.
The time of the gentleman has expired. The witness may answer the question.
As I explained, Congressman, I've heard Director Coates explain this, and he's better positioned than I.
So we don't know. Still don't know.
We welcome our distinguished witness. If you would please rise, I'll begin by swearing you in. Do you solemnly swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Let the record show that the witness answered in the affirmative. Mr. Rod Rosenstein was sworn in as the 37th Deputy Attorney General of the United States on April 26, 2017 by Attorney General Jeff Sessions. Mr. Rosenstein has had a distinguished career in public service. He began his legal career in the Public Integrity Section of the Department of Justice's Criminal Division and later served as counsel to the Deputy Attorney General and Principal Deputy Assistant Attorney General for the Tax Division. Until his appointment by President Trump, Mr. Rosenstein served for 12 years as the United States Attorney for the District of Maryland. He holds a bachelor's degree in economics from the Wharton School and a JD from Harvard Law School. General Rosenstein, your written statement will be entered into the record in its entirety, and we ask that you summarize your testimony in 5 minutes. Welcome. We're pleased to have you here.
Chairman Goodlatte, Ranking Member Nadler, members of the committee, I want to thank you for this opportunity to testify as part of your oversight of the United States Department of Justice. I appreciate your support and concern for the Department of Justice. I know several of you are alumni of the department. Two, in fact, served alongside me as United States attorneys, and I'm very grateful for the opportunity to be with you today. As Deputy Attorney General, my job is to help the Attorney General to manage our department's components, including 7 main justice litigating divisions, 94 U.S. Attorney's offices, the Federal Bureau of Investigation, the Drug Enforcement Administration, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the United States Marshals Service, the Office of Justice Programs, the Federal Bureau of Prisons, the Office of the Inspector General, and many others. Our department includes over 115,000 employees and tens of thousands of contractors stationed in every state and territory and in many foreign nations. We prevent terrorism and violent crime, illegal drug distribution, fraud, corruption, child abuse, civil rights violations, and countless other threats to the American people. We enforce tax laws, antitrust laws, and environmental laws. We represent the United States in the Supreme Court, the courts of appeal, and the district courts, and in state and territorial courts. We protect federal judges, manage federal prisons, review parole applications, oversee the bankruptcy system. We assist tribal governments, and we adjudicate immigration cases. We provide legal advice to the President and to every federal agency. We implement grant programs and support state and local law enforcement. We combat waste, fraud, and other misconduct involving employees and contractors. We resolve foreign claims and represent our government in international law enforcement forums. We collect, analyze, and disseminate law enforcement data, and we perform countless other important functions for the American people. Department of Justice employees are united by a shared understanding that our mission is to pursue justice, protect public safety, preserve government property, defend civil rights, and promote the rule of law. The mission attracted me to law enforcement, but the people who carry out that mission are what I treasure most about my job. With very few exceptions, they are honorable, principled, and trustworthy. America's federal, state, and local law enforcement agencies are more professional today than ever. Rigorous scrutiny by internal affairs offices and external oversight agencies has resulted in increased accountability and higher standards. When wrongdoing occurs, we are more likely to discover it, and we remedy it. That is critical to building and maintaining public confidence. Over the past 8 months, I've spoken with thousands of department employees around the country. I remind them that justice is not only our name, justice is our mission. Justice requires a fair and impartial process. And that's why we have a special responsibility to follow ethical and professional standards. In 1941, Attorney General Robert Jackson said that the citizen's safety lies in the prosecutor who tempers zeal with human kindness, seeks truth and not victims, serves the law and not factional purposes, and approaches the task with humility. Under the leadership of Attorney General Jeff Sessions and an experienced team appointed by President Trump, the Department of Justice is working tirelessly to protect American citizens and to uphold the rule of law. Today, I look forward to discussing some of our department's important work. Following the U.S. Attorney's Manual and the example set by past Department of Justice officials, we always seek to accommodate congressional oversight requests while protecting the integrity of our investigations, preserving the department's independence, and safeguarding sensitive information. Thank you, Mr. Chairman. I look forward to your questions.
The chair recognizes the gentlewoman from Texas, Ms. Jackson Lee, for 5 minutes.
Deputy Attorney General, thank you, welcome, and thank you for your service to the nation. Allow me just for a moment as I move on my questions to indicate that I am shocked and baffled the way some in the right-wing media and some of our friends on the other side show such contempt for the Department of Justice and the FBI and so much skepticism or mistrust of the Russian government. Let me briefly review for the record. The FBI and DOJ brought to justice and put away Timothy McVeigh, domestic terrorist who killed 168 Americans, Klansmen who murdered civil rights workers Goodman, Cheney, and Swerner, the Unabomber, terrorists who bombed U.S. embassies in Kenya and Tanzania, organized crime family kingpins, the murderer assassinated Medgar Evers, Pan Am 103 bombing, Soviet diplomat that had a spy ring during World War II, Aldra Ames, Richard Hansen, Alger Hiss, and others for espionage, World Trade Center bombing in 1993, TWA 847 hijacking, Lindbergh kidnapping, Beltway snipers, Klansmen who killed 4 little girls in the 16th Street church in Birmingham. And of course, on the other hand, the Russians are known for shooting down a civilian airline, KAL-007, killing 269 passengers and crew, annexing Crimea and invading Ukraine, killing journalists, propping up Assad, the butcher of Damascus, building the Berlin Wall, imposing an Iron Curtain against freedom, and committing cyber theft and conspiring and doing a sabotage of the American presidential election in 2016. Perhaps our friends on the other side of the aisle can show more respect for the FBI and the DOJ, as so many of us do, including myself. So let me ask these questions, and with my limited time, I really need just a yes or no. Are you in the business of helping to secure the elections in 2018 and making sure that there is an infrastructure in the DOJ to help states have secure elections? Yes or no?
Yes.
Special Counsel Mueller, I'm reminded, some of us would say we read it in the history books, of the Saturday Night Massacre. I know you must be aware of it. During the meeting of May 8, 2017, with you, Sessions, and the President, the day before Comey was fired, what did you discuss regarding the FBI investigation?
Congresswoman, as I explained previously, I'm not going to be discussing anything related to that until after the investigation.
Thank you very much, Mr. Deputy Attorney General. Let me then go forward with the question of the protection of the special prosecutor. Do you have in place a protection scheme or system that would void a potential Saturday night massacre? Do you, in fact, have the authority to stand up against the president who is putting out the right-wing media to taint the Mueller investigation? Will you protect Mr. Mueller if he deserves the protection and has done nothing to violate his duties and responsibilities?
As I've explained, if he hasn't violated
Is
his
that
duties,
yes or no, Mr. Deputy Attorney General?
I won't take any action unless he's violated his duties.
Let me show you these individuals here. It says that the Trump accusers want a day in court, or at least want to be heard. The president is the chief executive and law enforcement officer of the United States. Therefore, he is an officer of the United States. What does the Department of Justice, what intentions do you have to allow these women who are accusing the president of sexual misconduct and have never been heard in terms of a public setting, as many of us on this committee, women on this committee, Democratic women on this committee, have asked for this committee to hold a hearing with these women? What does the Department of Justice intend to do in light of the fact that the president is the chief law enforcement officer of the United States of America?
I don't think I have any position on that, Congresswoman. If they file a lawsuit, they're free to do so. It wouldn't be a department matter.
Would you not believe that it's important to give these women a forum to be heard? The Department of Justice, the FBI investigates. I just gave a long litany of the great successes of the Department of Justice.
If there's anything that warrants federal investigation, Congresswoman, we'd certainly look at it.
So can I refer these women, can we refer these women to the Department of Justice? If they walked up to the Department of Justice, would there be an intake officer, an FBI officer that would take their complaints?
If somebody wants to file a complaint of a potential federal crime, yes, they can report that to the FBI, or they can write. Anybody can do that at any time. And
Well, then let me publicly say to these women, you have one option at this time, is to go to the Department of Justice, as the Deputy Attorney General has just said to us, to be able to file a complaint, and I would encourage them to do that. I would also encourage this hearing as well, to do this committee to have hearings. Let me ask this last question regarding the whole question of commutation program of President Obama, and of course the memo by Attorney General Sessions that rescinds memos regarding the charging and sentencing policy, and also the use of private prisons. That was by Eric Holder. What is the position of the U.S. Department of Justice as it relates to a fair and just commutation program, and also the issues dealing with over-prosecution and the sentencing policy that was offered by Eric Holder, which was considered fair and just, and the use of private prisons had been known to be abusive to prisoners and do not allow FOIA requests to go forward? What is your position on that?
Time of the gentleman has expired. The Deputy Attorney General may answer the question.
I thank you.
Mr. Chairman. You've raised a number of issues, Congresswoman. I don't know that I have time to respond to them all, but I do just want to clarify, anybody is free to report to the Department of Justice when they believe a crime is committed. It's not a complaint in the way that you might file a complaint in some local police departments. You're free to report any allegations, and the department will conduct appropriate review, as we do with any allegations of alleged criminal conduct. We initiate investigations, though, only if we determine there's proper predication under our policies.
Well, I'm yielding back, Mr. Chairman, but he did not answer my question.
The time of the
Thank
gentleman
you.
has already expired. This is the gentleman from New York, Mr. Jeffries, for 5 minutes.
Thank you, Mr. Chairman. Mr. Rosenstein, there are approximately 14,000 special agents within the FBI, is that correct?
37,000 total employees.
And is it fair to say that a majority of those FBI special agents are registered Republicans?
I haven't asked them, and I wouldn't want to speculate.
Fair to say that a majority of the 14,000 FBI special agents have conservative-leaning political views, like much of the law enforcement community throughout the entire nation?
I'm certain that many of them do. I haven't counted.
Now, the Department of Justice apparently last evening invited a group of reporters to its offices to view the private text messages that were sent during the election by Peter Strzok and Lisa Page. Is that correct?
I believe that's correct.
Now, who exactly authorized the Department of Justice in advance of a congressional hearing to invite reporters to come view private text message communications between two Department of Justice employees who are the subject of a pending investigation? Did you give that order,
I
sir?
think it's a very important question you asked, Congressman, because that was one of my concerns about this issue, is what is the status of these messages? and is it appropriate to release them? And the determination was made that it is. So we gave notice to their attorneys, we notified the committee, and our goal, Congressman, is to make sure that it's clear to you and the American people, we are not concealing anything that's embarrassing to the FBI.
So is it extraordinary that you would invite reporters for a private viewing in advance of a congressional hearing?
Only if the information is appropriate for public release. If it's not appropriate for public release, it is never appropriate to disclose it to reporters.
Okay, now Shannon Bream is a Fox News Supreme Court reporter. She tweeted last evening at 9:29 that Fox News producer Jake Gibson has approximately 10,000 text messages between Peter Strzok and Lisa Page. Now, it's my understanding that only about 350 or so were released to this committee. Is that correct?
There are others that are being reviewed, and we've assured the committee chairs that we're going to produce them as soon as we have them available. There's some redactions that need to be made.
So how is it possible that Fox News apparently has 10,000 text messages?
I wouldn't assume that's true just because it was in the news, Congressman. I'm not aware of that.
Okay, but this is a Fox News reporter who's indicating that. I'm sure we're going to get to the bottom of it. Hopefully, the chairman in a bipartisan way would be interested in what
be
is
very
clearly
concerned if there-
would be a violation of law and Department of Justice proceedings.
If there were any evidence that we disclosed information to a reporter that wasn't appropriate for public release or wasn't disclosed to the Congress, I would agree with you. I'm not aware of that.
Okay, now Department of Justice investigations should be free of political interference, true?
Absolutely.
Can we put up a tweet from Donald Trump on November 3rd at 3:57 a.m. in the morning? God knows what he was doing at that time other than tweeting. It says, everybody, can we put that tweet up?
Mr. Chairman, may I ask the unanimous consent that the clock stop while we're trying to...
What was the gentleman's request?
Yeah, the committee had been given notice of a tweet that I wanted displayed on the screen last evening, and I've been asking for that to be put up.
And there's some technical difficulty in doing that? Yes. All right, yeah, we'll suspend.
Mr. Chairman, I believe the gentleman had 1 minute and 45 seconds.
We'll make sure he gets plenty of time.
Thank you, Mr. Gates. Well, in the interest of time, Mr. Chairman, I'll just read what was written by the president. He said, everybody is asking why the Justice Department and FBI isn't looking into all of the dishonesty going on with crooked Hillary and the Dems. Let me ask you a question. Is it ever appropriate for a president, any president of the United States, to encourage the Department of Justice to launch criminal investigations against his or her perceived political enemies?
I'm not going to comment on that, Congressman. As I've explained previously, the President has put a team of experienced folks in charge of the Department of Justice, and we are not going to be influenced by anything other than the facts and the law.
Was that an appropriate tweet for the President of the United States to send?
It's not my role to opine on that.
Did the President's repeated attempts to encourage criminal prosecutions against perceived political enemies concern you, sir?
Congressman, as I said, we understand our responsibility, and we're going to continue to conduct our responsibility in accordance with the facts and the law. And I am grateful that the President has put an experienced team in charge of the Justice Department who understand what to do.
Okay, thanks. On June 20th, the New York Times published a wide-ranging interview with Donald Trump. In it, the President criticized you for being from Baltimore, saying there are very few Republicans in Baltimore, if any. So he's from Baltimore.
That's true.
Mr. Rosenstein, are you unable to be fair and impartial because you're from Baltimore?
Well, I'm actually not from Baltimore. I did work in Baltimore for 12 years. It's true that there are not a lot of Republicans in Baltimore.
Okay, Donald Trump's statement had no basis in reality, correct?
Well, as I said, that part of it was true.
Okay, Preet Bharara is the former U.S. Attorney for the Southern District of New York, true?
Yes,
And he was fired by Donald Trump in March, is that correct?
along with almost all sitting U.S. attorneys.
And the U.S. Attorney's Office for the Southern District of New York has prosecutorial jurisdiction over Trump Tower in Manhattan, correct?
has jurisdiction over everything in its jurisdiction.
Okay, in presidential interviews of U.S. attorney candidates, as has been reported to be the case for Preet Bharara's replacement, that would be a departure from traditional presidential protocol, correct?
For the president personally to conduct the interview?
That's correct.
I'm not aware of all the prior practices. I don't think it was done in the last two administrations that I'm familiar with.
Okay. And you were appointed by President Bush and then continued in that position as U.S. Attorney for Maryland by Barack Obama. That's correct.
That's correct. As a matter of law, I was appointed and never removed.
Okay. Were you ever asked by President Bush for a loyalty pledge?
No.
Were you ever asked by President Barack Obama to take a loyalty pledge?
No.
Is it ever appropriate for the President of the United States to demand that the Department of Justice official or FBI director take a loyalty pledge?
I don't have any opinion about that, Congressman. Nobody's asked me to take a loyalty pledge other than the oath of office.
Thanks. I yield back.
Good morning. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare recesses of the committee at any time. We welcome everyone to this morning's hearing on oversight hearing with Deputy Attorney General Rod Rosenstein. And I'll begin by recognizing myself for an opening statement. Thank you, Attorney General Rosenstein, for appearing for the first time in front of this committee. There is much to discuss today, and we look forward to your testimony and answers to your questions. As chairman of the committee with primary oversight of the Department of Justice and the FBI, I have always supported the department and the FBI in performing their valuable missions to keep our nation safe and to hold individuals accountable for criminal conduct. Yet, I and many on this committee now find ourselves in the very difficult position of questioning the actions of both prior and current department and FBI leadership. You have a unique role at the Department of Justice in that you appointed Special Counsel Mueller and have a supervisory role over his investigation. It is therefore very appropriate for you to appear before this committee to answer questions related to the scope of the Special Counsel's investigation, as well as its current efficacy in light of various events calling into question its impartiality. Reports on the political predisposition and potential bias of certain career agents and department lawyers on Special Counsel Mueller's team are deeply troubling to all citizens who expect a system of blind and equal justice. The Department of Justice investigations must not be tainted by individuals imposing their own political prejudices. We are now beginning to better understand the magnitude of this insider bias on Mr. Mueller's team. First, we have FBI agent Peter Strzok and FBI lawyer Lisa Page exchanging communications showing extreme bias against President Trump, a fact that would be bad enough if it weren't for the fact that these two individuals were employed as part of the Mueller Dream Team investigating the very person for whom they were showing disdain. And calling it mere disdain is generous. According to the documents produced last night to this committee, Mr. Strzok and Ms. Page referred to the president as an utter idiot, a loathsome human, and awful, while continually praising Hillary Clinton and the Obamas. These text messages prove what we all suspected. High-ranking FBI officials involved in the Clinton investigation were personally invested in the outcome of the election and clearly let their strong political opinions cloud their professional judgment. And this was only an initial disclosure containing heavy redactions. Second, former embattled FBI General Counsel and current Mueller prosecutor Andrew Weissmann expressed his awe of a former DOJ official for shunning the president and failing to faithfully execute the law. However, we are the ones now in awe that someone like Mr. Weissmann remains on an investigative team that looks more and more partisan. Third, we have learned that a top Mueller prosecutor, Jeannie Rhee, in addition to the other actions that would normally justify recusal, served as an attorney for the Clinton Foundation. Aren't Department of Justice attorneys advised to avoid even the appearance of impropriety? A former Clinton employee is now investigating President Trump. This seems to be the very definition of appearance of impropriety. Fourth, We have just recently learned that another top Department of Justice official, Bruce Orr, has been reassigned because of his wife and his connections with the infamous dossier and the company from whom the opposition research document originated. We hope to hear your assessment of the foregoing conflicts, whether individuals are being held accountable, and whether you still have confidence in the judgment of the special counsel you named and supervise. Regarding the Clinton email scandal, you, along with Attorney General Sessions, have to date declined to appoint a second special counsel to investigate the improprieties that continue to surface related to the handling of the Clinton email investigation and other events surrounding the 2016 election. These are some of the important issues on which we will focus our energy and questions today. We want to understand your participation and the department's involvement in addressing both investigations. Mr. Deputy Attorney General, the Department of Justice's reputation as an impartial arbiter of justice has been called into question. This taint of politicization should concern all Americans who have pride in the fairness of our nation's justice system. While we continue to call on you to appoint a second special counsel, as you are aware, we have also opened our own joint investigation with the House Oversight and Government Reform Committee to review FBI and the Department of Justice's handling of the Clinton email investigation. I want to thank you and Attorney General Sessions for recently committing to provide us relevant documents to enable robust congressional oversight of this matter. I implore you to continue to work with us on these and other important matters facing our nation. One of these matters involves a critical program for our national security, FISA Section 702. This committee passed, on an overwhelming bipartisan basis, the USA Liberty Act, which maintains the integrity of the program while protecting cherished civil liberties. This overwhelming vote occurred despite the department's lobbying efforts against our bill. The USA Liberty Act was characterized as bad for the program, highly problematic, unworkable, and a proposal that would effectively dismantle Section 702. However, the reality is that this committee's legislation struck a balance that promotes national security and civil liberties. I hope to hear from you why the Department of Justice felt it necessary to oppose a bill that would reauthorize 702 and instill confidence in the American people that their privacy and civil liberties are respected by a government whose duty it is to protect them. The Department of Justice must reacquire the trust of the American people. I know there are thousands of Department of Justice employees and line agents in the department, in the Bureau Federal Bureau of Investigation, that are dedicated individuals that are dedicated to upholding the rule of law and protecting the American people. And I hope that we can come to a conclusion about those people who have not met that standard in this hearing today. Thank you, Mr. Deputy Attorney General, for appearing today. Thank you, Mr. Rosenstein. I'll start by recognizing myself for questions. Last week, Director Wray indicated that the normal procedures were not followed in the investigation of former Secretary Clinton's email server. He said it was not normal protocol to have witnesses sit in the room during an interview of the target of an investigation. If the Inspector General determines that normal protocol was not followed, or that the investigation was closed or otherwise tainted for political purposes, would that be a justification in your mind to reopen the investigation?
Mr. Chairman, we are certainly anticipating the outcome of that Inspector General investigation. As you know, that's been ongoing for some time. I'm hopeful that it'll be concluded within the next couple of months. And when we get those results, we'll take appropriate action. I don't know exactly what the findings are going to be, but it's always appropriate for us to review any findings of impropriety or misconduct and take appropriate action.
When you announced your decision to terminate the employment of FBI Director Comey, in that decision, you announced some practices that I took it to mean you thought were inappropriate actions on the part of the former FBI Director. Do you think that those actions on his part would merit further investigation into how that whole matter was conducted?
Mr. Chairman, as you're aware, the Inspector General is conducting an investigation into the handling of that Hillary Clinton email investigation. And I believe that the matters that you've referred to are part of his investigation. The memo that you're familiar with, that I provided, reflects my personal opinion. It's not an official finding of misconduct. That's the Inspector General's job. He'll reach his own independent determination. But as you pointed out, my views about it are already known.
Are you aware of any prior efforts by the Judiciary Committee, this committee, to unduly restrict the ability of the intelligence community to do its job of protecting our national security?
I'm not personally aware of any, no, sir.
Are you aware that this committee has primary oversight of the Foreign Intelligence Surveillance Act due in part to the significant constitutional and legal questions that government surveillance raises?
Mr. Chairman, I respect the Congress's decision about which committee has oversight. I know that both this committee and the Intelligence Committee have an interest in that issue.
Well, given that you understand this committee's jurisdiction and its history of providing the intelligence community with the tools it needs, why would we, in the words of the department, attempt to, quote, dismantle Section 702 of our nation's most important surveillance program?
Well, I certainly would hope that wouldn't be the case. I don't know who made the statement you're referring to. I know the department obviously has expressed its opinion about the reauthorization, which we think is critically important in Section 702. I respect there are differences of opinion, but I think the department has been very clear that we believe it's essential to national security that Section 702 be reauthorized.
Well, we agree with you that it's essential that Section 702 be reauthorized. We also believe that it's essential that the civil liberties of American citizens be protected and that a standard be imposed on the examination of information about U.S. citizens incidentally gathered as a part of the Section 702 program with the surveillance of non-U.S. citizens outside the United States, but incidentally gathering information about U.S. citizens and then being looked into by agents of the Federal Bureau of Investigation without a warrant. I'm not aware of that being appropriate in any other type of investigation that they might conduct. And we're not talking about terrorist attacks. We're not talking about national security because we have clearly distinguished that. We're simply talking about crimes that have already occurred that are being investigated as they should be investigated by the department, but under the procedures that the American people would expect that they would follow to protect their civil liberties in other circumstances.
Mr. Chairman, as you know, I've had the advantage over the last 8 months of having a role in overseeing our national security operations. I discussed this with Director Wray yesterday, and if you'd like, I could give you a detailed explanation. It might take a couple of minutes, but I'd be happy to give you some details. But the bottom line is that it really is critical to national security that the FBI have the ability to query the data. That's the issue here.
And our legislation allows them to do that. But if the query provides a hit that they want to read an email, they want to see other documentation, they want to see in its full form, they're required to get a warrant under those circumstances.
And I discussed this with Director Wray, and what happens when the FBI conducts these queries, Mr. Chairman, is that typically they're leads that are not necessarily based on probable cause, but based on a lead, a suspicion, and the ability to query that data and then follow up on it gives the FBI the opportunity to put two and two together, to connect the dots.
There are lots of leads that any law enforcement person would like to pursue, but we have protections against them pursuing it without appropriate standard for doing it in a whole host of other ways to protect people from unreasonable searches. And this is a search of information about a United States citizen.
Well, it's a query as a constitutional matter. What we're
Allow the
talking
initial
about,
query. Once that results in something the agent wants to look at, I don't see how you distinguish the further reading of emails or other things from a search.
If I could take a couple of minutes, I could explain to you, I talked with Director Wray about an appropriate way to explain this publicly. Hypothetically, let's say, for example, that local police department receives a call that somebody has purchased a large quantity of hydrogen peroxide, and something made the clerk at the store suspicious about that, so he contacts the local police. There's no probable cause. There's nothing illegal about what the person did, but something that caused concern. The local police may refer
General
that-
Rosenstein, let me interrupt you because the very specific instance that you are citing was cited to us in our discussions with the FBI, and that very specific protection for the FBI was added to our legislation.
Well, the example I'm providing is a situation where there would not be probable cause, but we think it would be appropriate for the FBI to follow up. And what we're trying to avoid is a situation where we re-erect a wall that would prevent the FBI from gaining access to information that might allow them to connect a lead to information that implicates national security.
Thank you. My time has expired, and the chair recognizes the gentleman from Florida, Mr. Gates, for 5 minutes.
Was Peter Strzok the author, recipient, carbon copy, blind carbon copy on any documents relating to the meeting between Loretta Lynch and Bill Clinton on the Arizona tarmac?
I do not know the answer to that.
Will all of the documents relating to that tarmac meeting be produced in an unredacted format?
Congressman, the Inspector General is handling that investigation, and as I said, we're going to try to accommodate any congressional requests that we can, but I'll have to consult with them before I do.
So if the president declassified the documents, how quickly could they be produced?
If documents are declassified, they could be produced fairly quickly.
Is that like within a week?
Well, it would depend upon the sensitivity of the document. I can't answer.
If they were declassified, I guess they wouldn't be sensitive anymore. So, I mean, could we get them within a week?
Which documents are we talking about,
The documents relating to the tarmac.
well, I don't know if I don't know if they're classified. I don't know.
No, assuming they're
anything about it.
declassified. How quickly would it take to get them from you to us if the president declassified them?
If there are documents that's appropriate to disclose, then we disclose them as quickly as we could.
When did Justice first learn that Nellie Orr was employed by Fusion GPS?
I do not know the precise date, Congressman.
Can you find that out and get it to us?
Well, if we know it, yes.
Well, we got to find that out, right? I mean,
Yes.
you've got the wife of someone who was one of the top counterintelligence officials in the Department of Justice working for the company that was a pass-through for money from the Democratic committee to Russians to get dirt on the president to discredit him both before and after the election. I feel like it should be a pretty high priority to figure out when that occurred,
I
right?
don't want to quibble with you except to say that Mr. Orr is not a counterintelligence official, but yes, I agree with you. In fact, I believe Mr. Orr is scheduled to testify before one of the committees, or at least to be interviewed next week.
Right, but that doesn't absolve us of the obligation to actually go and find out when his wife started working for these people that wrote this salacious and unverified dossier. So when did the Department of Justice learn of Bruce Orr's contact with Christopher Steele during the 2016 campaign?
Congressman, I'm reluctant to answer that only because I don't know all the information, and I want to make sure we know all the information before we give any answers.
We too want to know all the information. That's why we keep asking these questions. I mean, again, you've got this person who works at the Department of Justice, whose wife is working for Fusion GPS, and during the campaign, he's meeting with the author of a dossier that Mr. Comey called salacious and unverified. And so I would hope that it would be a top priority to figure out when we first came to know of those meetings. Is that something you can get to the committee?
If we get all the information and we have a firm answer, I don't want to answer any questions until I know all the details.
When did the Department of Justice first learn of Bruce Orr's contact with Fusion with Glenn Simpson after the election?
Congressman, we have agreed to provide all the relevant documentation to the Intelligence Committee. I haven't seen it all, so I'm not in position to answer it.
So during Mr. Shavitz's questioning, he pretty thoroughly laid out the number of people on Mr. Mueller's team who have financial donations to Democrats, the Clinton-Obama campaigns. I mean, I think over half of the Mueller team donated to either Clinton or Obama. None of them donated to Trump. And so that's either one of two things. Either Mr. Mueller was curating a universe of people who hate the president, or it's just one hell of a coincidence that a whole lot of people had demonstrable bias that we learn more and more about each day. And so you've answered that question by saying, look, people have personal opinions, but that doesn't always influence action. And it's the action that is your responsibility to make sure is not infected by this bias.
Correct.
And I would proffer that, like, when Mr. Strzok goes and changes wording from gross negligence, a crime, to extremely careless, that's not a belief, that's an action. Like, if we can't find out, you won't tell us whether or not taxpayer money was used to go and buy this dossier. If it was, if the FBI was working with the Democratic Party to buy a dossier to discredit the President of the United States, that's not a belief, that's an action. If that dossier was dressed up as an intelligence document and brought to a FISA court, that wasn't a belief, that was an action. If Bruce Orr is meeting with the author of the dossier during the campaign and the head of Fusion GPS after the campaign, and as you sit here today, you can't tell us when that occurred, Those meetings aren't beliefs, they're actions that undermine the credibility of this investigation. And I would certainly suggest that when Mr. Weissman, Mueller's number 2 in this probe, sends an email on his official Department of Justice email to Sally Yates praising her for defying the President of the United States, that's not a belief, that's an action. So my question to you is, like, what do we ultimately have, what do you have to see in terms of the actions of people with demonstrated bias against the President of the United States before you will appoint a special counsel to investigate the clear bias that has infected this investigation?
Well, Congressman, there are a number of different issues that you've raised. With regard to the allegations of bias, as I've explained, our Inspector General is conducting a very thorough review of that. He's the one who identified the text messages. And so I'm confident that's going to be done appropriately. We're going to
Mueller didn't, right? It took the Inspector General doing it. Mr. Mueller didn't find this information.
Well, I don't, Mr. Mueller found it when somebody told him about it, but it was in the text messages, which the IG got access to.
It really makes you wonder how all these people that we're finding all this information about, with all these connections, ended up on his team. I yield back, Mr. Chairman.
Mr. Chairman.
The chair recognizes the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Did the FBI pay Christopher Steele, and was the dossier the basis for securing warrants at the FISA court to spy on Americans associated with the Trump campaign? Really, when you sum it all up, it boils down to those fundamental questions. Did you pay the guy who wrote it? And did you use what he wrote, disproven, discredited dossier paid for by the Clinton campaign? Did you use it to go get warrants to spy on Americans? That's what it comes down to. And you're the guy who can answer those questions. And yesterday I was convinced that the answer to those questions was probably yes. But today I'm even more convinced the answer is yes, based on the text messages we got to read early this morning. Mr. Rosenstein, you know Peter Strzok, you familiar with that name?
Yes, I'm familiar with the name. And
Former deputy head of counterintelligence at the FBI? Peter Strzok, that one?
I don't know his precise title, but yes, he had a significant role in.
Peter Strzok ran the Clinton campaign, interviewed Mills, Abedin Clinton, changed the exoneration letter from gross negligence to extreme carelessness. Peter Strzok, who ran the Russian investigation, interviewed Mike Flynn. Peter Strzok selected by Mr. Mueller to be on his team. That Peter Strzok, we learned, had all these text messages. We got to read some of them early this morning. Now, as my colleagues have pointed out, some of them are, they're show he didn't like Trump. He and Miss Page are exchanging text messages back and forth, show they don't like the president. But that's nothing new. Everyone on Mueller's team, no one on Mueller's team likes Trump. We already knew that. But I want to focus on one in particular. One in particular. And this is a text message from Mr. Strzok to Miss Page, recalling a conversation and a meeting that took place in Andrew McCabe's office, Deputy Director of the FBI, recalling a meeting earlier. And Mr. Strzok says this: I want to believe the path you threw out for consideration in Andy's office. Then there's a break. Dash, it says that there's no way he gets elected. No way Trump gets elected. He says, I want to believe that. You said that in the meeting in Andrew McCabe's office. I want to believe that. But then he goes, but I'm afraid we can't take that risk. Now, this goes to intent. He says, we can't take the risk. The people of this great country might elect Donald Trump president. We can't take this risk. This is Peter Strzok, head of counterintelligence at the FBI. This is Peter Strzok, who I think had a hand in that dossier that was all dressed up and taken to the FISA court. He's saying we can't take the risk. We have to do something about it. Now, don't forget the timeline here either, Mr. Rosenstein. Peter Strzok, January 10th, he's the guy who changes the exoneration letter from gross negligence, criminal standard, to extreme carelessness. July 2nd, he's the guy who sets in on the Clinton interview. July 5th, 2016, that's when Comey has the press conference and says, we're not going to prosecute. Clinton's okay, we're not going to prosecute. And then August 2016, we have this text message. The same month that the Russian investigation is opened at the FBI, August 2016. And my guess is that's the same month that the application was taken to the FISA court to get the warrants to spy on Americans. Using this dossier that the Clinton campaign paid for, Democrats paid for, fake news, all dressed up, taken to the court. So I got really just a couple basic questions. Because it seems to me if the answer to any of those two questions, if the answer is yes, if you guys paid Christopher Steele at the same time the Democrats in the Clinton campaign were paying, or if you took the dossier, dressed it all up, took it to the FISA court, and used that as the basis to get warrants, And now we have intent in this text message saying, there's another text message, my colleague referenced it earlier, where Mr. Strzok says, I can protect our country at many levels. Says it with all the humility he could muster. I can protect our country at many levels. This guy thought he was Super Agent James Bond at the FBI. This is obvious. I'm afraid we can't take that risk. There's no way we can let the American people make Donald Trump the next president. I got to protect our country. This is unbelievable. And I'm here to tell you, Mr. Rosenstein, I think the public trust in this whole thing is gone. So it seems to me you got two things you can do. You're the guy in charge. You're the guy who picked Mueller. You're the guy who wrote the memo saying why he needed to fire Comey. You're the guy in charge. You could disband the Mueller special prosecutor, and you can do what we've all called for. Appoint a second special counsel to look into this, to look into Peter Strzok, Bruce Ohr, everything else we've learned in the last several weeks.
Yes, Congressman, and I can assure you that I consider it very important to make sure the thorough review is done, and our Inspector General is doing a thorough review. That's how we found those text messages as part of that review.
You've given that answer like 15 times. Let me ask you this. Are you concerned? I mean, this is what a lot of Americans are believing right now, and I certainly do, that the Comey FBI and the Obama Justice Department worked with one campaign to go after the other campaign. That's what everything points to. Think about what we've learned in the last several weeks. We first learned they paid for the dossier, then we learned about Peter Strzok, and last week we learned about Bruce Ohr and his wife Nellie. I mean, this is unbelievable. So what's it going to take to get a second special counsel to answer these questions and find out, was Peter Strzok really up to what I think he was?
I think it's important to understand, Congressman, we have an Inspector General who has 500 employees and a $100 million budget, and this is what he does. He investigates allegations of misconduct involving department employees. That review that he is conducting is what turned up those text messages. It will also involve interviews of those persons and of other witnesses.
And we're looking forward to his report, and we've met with Mr. Horowitz, and we're anxiously awaiting that report. But that doesn't dismiss the fact that the country thinks we need a second special counsel. 20 members of this committee, the Judiciary Committee with primary jurisdiction over the Justice Department, thinks we need a second special counsel. All kinds of senators think we need a special counsel. What fact pattern do you have to have? What kind of text message do you have to see before you say it's time for a second special counsel?
I want to assure you, Congressman, as I think the Attorney General explained, we take very seriously the concerns of 20 members of this committee or one member of this committee, but we have a responsibility to make an independent determination, and we will.
I thank the chair.
The chair recognizes, the time of the gentleman has expired. The chair recognizes the gentleman from Tennessee, Mr. Cohen, for 5 minutes.
Thank you, Mr. Chair. First, I want to thank you for your service to the country and for accepting the difficult position under the difficult circumstances that you have. Has President Trump ever communicated with you about removing Robert Mueller from his role as special counsel?
Congressman, I am not going to be discussing my communications with the President, but I can tell you that nobody has communicated to me a desire to remove Robert Mueller.
You said you're not going to relate your conversations with President Trump. How many conversations have you had since your appointment with President Trump?
I'm the Deputy Attorney General, Congressman, and it's appropriate for me to talk with the President about law enforcement issues, and I don't believe that's an appropriate issue for discussion.
When you chose Robert Mueller to be the special counsel, what were his characteristics, his history, and the reasons for you to have chosen him for this important position?
I think it would be very difficult, Congressman, for anybody to find somebody better qualified for this job. Director Mueller has, throughout his lifetime, been a dedicated and respected and heroic public servant. He, after college, volunteered to serve as a Marine in Vietnam, where he was wounded in combat. He attended law school and then devoted most of his career to serving as a federal prosecutor. With the exception of brief stints in private practice, he served as United States Attorney in 2 districts in Massachusetts and in Northern California. He served in many other positions in the department after he lost his position as the head of the criminal division when President Clinton was elected in 1992. Mr. Mueller briefly went into private practice, and then he went back at an entry-level position as a homicide prosecutor trying to help with the violent crime problem in the District of Columbia in the early 1990s. He then rose once again through the ranks and ultimately was confirmed, I believe unanimously, as FBI director, protected this nation after 9/11. And then when his 10-year term expired, he was so well respected that his term was extended, I believe also almost unanimously for another 2 years. So I believe that based upon his reputation, his service, his patriotism, and his experience with the department and with the FBI, I believe he was an ideal choice for this task.
Thank you, sir. I agree with you. FBI Director Wray agrees with you. He said that the similar thoughts. He said he was a smart lawyer, a dedicated public servant, well respected within the FBI. I think everybody on the other side of the aisle agreed with you when you appointed him, and everybody in this Judiciary Committee and probably everybody in this Congress agreed with his appointment as FBI Director, which was unanimous, his reappointment, which was unanimous by Republican Bush and Democrat Obama. Everybody respects that man in this country. He may be the most respected man in this. Obviously, we knew that would be an exception. But the fact is, they didn't start to dislike him until he started to get issues that affected the president that currently serves this country. And because of that, they've said the FBI was in tatters, that the FBI, the chief law enforcement, top law enforcement folks in this country are questionable. Some of their allies on television said they're like the KGB. They've questioned you, they've questioned the Justice Department, they've questioned some of the most loyal, dedicated, fearless people in our country who serve the rule of law. And I find it repugnant and awful, and I wonder what you think about it when you hear about the FBI, which works under you, being suggested it's in tatters and that there's something wrong with the FBI and that they're somehow like the KGB.
Well, Congressman, as I know you're aware, I've expressed concern with certain aspects of certain things done by the FBI, but in general, throughout my experience working with FBI agents over the decades, I found them to be an exceptional group of public servants, very loyal, faithful, and dedicated. And I believe some of the finest people that I know are agents of the Federal Bureau of Investigation.
I thought about them, sir, when I watched the Army-Navy game. And I thought about them because I have the honor, as everybody up here has, of recommending some folks to be at West Point and at Annapolis. Those are the cream of the crop. And the people at the FBI are in law enforcement. They're the cream of the crop. And Justice Department attorneys are too. It's not easy to get a job in justice, no matter where you went to law school and what you did. You hire the best. You always have. I compliment you on that. I hope and know you will continue to hold the Department of Justice up as a pantheon of outstanding lawyers and jurists and take justice where it should go, as truth demands and justice dictates. I yield back the balance of my time.
I recognize the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Judge Poe. There are a lot of issues that I would like to ask you about, Mr. Deputy Attorney General. We had a terrorist incident in New York this week. We have 702 reauthorization that is pending in Congress. Gun violence, the opioid epidemic, criminal justice reform. But when I go home to South Carolina this weekend, trust me when I tell you, no one is going to ask me about any of those issues. They're going to ask me, what in the hell is going on with the Department of Justice and the FBI? The reason we have special counsel, this is a very important point, and you know it, the reason we have special counsel is because of a conflict of interest. The regulation itself specifically makes reference to a conflict of interest. And we don't like conflicts of interest because it undercuts people's confidence in both the process and the result. So let's be really clear why we have special counsel. There was either a real or perceived conflict of interest that we were fearful would either impact the result or people's confidence in the process. That's why we have something called special counsel, and that's why we have special counsel in this fact pattern. And then lo and behold, those who are supposed to make sure there are no conflicts of interest seem to have a few of their own. There's a senior prosecutor who sent obsequious emails to a fact witness. She can be described as nothing other than a fact witness. She's a really important fact witness if you pursue the line of inquiry that my Democrat friends want to pursue. They got off of collusion and now they're on obstruction of justice. She may be the most important fact witness in an obstruction of justice case. And the senior prosecutor for this conflict of interest-free special counsel sent a fawning, obsequious email to a fact witness. And then we have prosecutors assigned to conduct this investigation who donated almost exclusively to one candidate over another. And then we have a prosecutor assigned to this conflict of interest-free team that attended what was supposed to be, what he'd hoped to be, a victory party for Secretary Clinton. And we have a senior DOJ official, Mr. Deputy Attorney General, with an office that used to be 2 doors down from yours, meeting with Fusion GPS. And Fusion GPS, of course, was paying for Russian dirt on the very person that they're supposed to be objectively investigating. And then that same senior DOJ official's wife, the one that met with Fusion GPS, his wife was on the payroll of Fusion GPS. And then we have a senior agent assigned to investigate Secretary Clinton's email, help draft the exoneration letter where we changed the language from grossly negligent to extremely careless, interviewed Secretary Clinton in an interview I've never seen, and I doubt you have either in your career as a prosecutor, interviewed Michael Flynn, was actively involved in the investigation into the Trump campaign before the Inspector General found his text. So this agent, in the middle of almost everything related to Secretary Clinton and President Trump, sent pro-Clinton texts, anti-Trump texts to his paramour in response to being told maybe he is where he is to protect the country from that menace, Donald Trump. He said, I can protect our country at many levels. And then he said Hillary Clinton should win 100 million to nothing. Now think about that, Mr. Deputy Attorney General. That's a pretty overwhelming victory. 100 million to 0. And when I read that last night, what I thought was this conflict of interest free senior agent of the FBI can't think of a single solitary American who would vote for Donald Trump. That's where the 0 comes in. Not a single solitary American he can imagine would vote for Donald Trump. This is the conflict of interest free special agent assigned. And then he went on, if that weren't enough, to belittle Trump supporters by saying he could smell them at a Walmart in Virginia. This is the person we needed to avoid a conflict of interest. And then he said this, they fully deserve to go and demonstrate the absolute bigoted nonsense of Trump. But he wasn't content to just disparage Donald Trump. He had to disparage Donald Trump's family. This is what he said, Mr. Deputy Attorney General. He said, the douchebags are about to come out. He's talking about our First Lady and children. This conflict of interest-free special agent of the FBI. This is who we were told we needed to have an objective, impartial, fair, conflict of interest-free investigation. So he's openly pulling for the candidate he had a role in clearing, and he's openly investigating a candidate that he has bias against. And then if that's not enough, he says Trump is an effing idiot. What the F just happened to our country? This is the same man that said he would save our country. What happens when people who are supposed to cure the conflict of interest have even greater conflicts of interest than those they replace? That's not a rhetorical question. You nor I nor anyone else would ever sit Peter Strzok on a jury. We wouldn't have him objectively, dispassionately investigate anything knowing what we know now. Why didn't we know it ahead of time? And my last question, my final question to you, and I appreciate the chairman's patience, how would you help me answer that question when I go back to South Carolina this weekend?
Congressman, first of all, with regard to the special counsel, Mr. Strzok was already working on the investigation when the special counsel was appointed. The appointment that I made was of Robert Mueller. So what I'd recommend that you tell your constituents is that Robert Mueller and Rod Rosenstein and Chris Wray are accountable, and that we will ensure that no bias is reflected in any of the actions taken by the special counsel or in any matter within the jurisdiction of the Department of Justice. When we have evidence of any inappropriate conduct, we're going to take action on it. And that's what Mr. Mueller did here. As soon as he learned about this issue, he took action. And that's what I anticipate that the rest of our prosecutors, our new group of U.S. attorneys, our Justice Department appointees They understand the rules, and they understand the responsibility to defend the integrity of the department. And if they find evidence of improper conduct, they're going to take action. So, Congressman, that's the best assurance I can give you. But actually, there's one other point, which is you should tell your constituents that we exposed this issue because we're ensuring that the Inspector General conducts a thorough and effective investigation. And if there is any evidence of impropriety, he's going to surface it and report about it publicly.
I'll try.
Time of the gentleman has expired. The chair recognizes the gentleman from Rhode Island, Mr. Cicilline, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Rosenstein. In February, the Department of Justice changed its litigation position in Veazey versus Abbott, the Texas photo ID case. Did you have any involvement in this decision to reverse the Justice Department's longstanding position in this case that the Texas voter ID law was intentionally discriminatory?
No, I did not.
In August, the Department of Justice changed its litigation position in the case Husted versus H. Philip Randolph Institute. The Justice Department is now defending Ohio's voter purging law. Were you involved in the decision to change this litigation position and now side with the voter purging law?
I was at the department at that time, but I don't believe I had any involvement in the decision.
And were you involved in the Justice Department's decision to file an amicus brief in Masterpiece Cake Shop versus Colorado Civil Rights Commission on behalf of the baker who seeks to deny baking wedding cakes to same-sex couples?
Well, that decision was made by our Inspector General, our Solicitor General.
You described the special counsel as a heroic figure who served his country, a career prosecutor, someone who was confirmed unanimously as the FBI director, someone of extraordinary reputation, service, and patriotism. I take it your judgment on Mr. Mueller has not changed today.
Correct.
And you would not have appointed a special counsel or appointed Mr. Mueller if you thought he was going to engage in a witch hunt, correct?
Correct.
And so it's you then would disagree with the president's labeling of the special counsel's investigation as a witch hunt, I assume.
I don't know exactly what the president meant by that, Congressman. The special counsel's investigation is not a witch hunt.
Well, it's not a witch hunt. The president said is you disagree. I mean, you're supposed to be independent. You can answer a question contrasting the president. You disagree it's a witch hunt. The president's wrong, correct?
I do not know what the president meant by that, Congressman.
Okay.
I can only answer for myself.
Do you believe that the repeated attacks on the credibility of Special Counsel Mueller, whether by conservative pundits on TV or by my colleagues here in Congress, threatens to undermine the credibility of the independent investigation?
The independence and integrity of the investigation is not going to be affected by anything that anybody says.
You delivered remarks on October 25th before the U.S. Chamber of Commerce, and I quote, you said, if we permit the rule of law to erode when it does not directly harm our personal interests, the erosion may eventually consume us as well. The rule of law is not self-executing. If it collapses, if the people lose faith in the rule of law, then everyone will suffer, end quote. In the context of the president's attacks, the American people are really witnessing an unprecedented attack on our democratic institutions by this president. First, diminishing the seriousness of the investigation which is underway about Vladimir Putin's interference on our elections, attacks on the judiciary, attacks on the free press. The one institution which continues to enjoy broad public support and remains key to protecting the rule of law is the Federal Bureau of Investigation and the Department of Justice. America is counting on your integrity and your commitment to protecting the independence of the special counsel to reaffirm our commitment to the rule of law. And so when you said just a moment ago that you don't have an opinion about a loyalty oath from the president being asked of people, it might be useful to remind you, sir, that members of the Department of Justice take an oath to the Constitution. And so a loyalty oath to the President of the United States is inappropriate for any president to ask for it and for anyone to swear it. Do you agree?
Congressman, nobody has asked me for a loyalty oath.
That's not my question, sir. My question is, you are here to demonstrate the independence of your office, and you are unwilling to say that an oath to the President of the United States rather than to the Constitution is not inappropriate. That does not inspire a lot of confidence.
Say that. An oath to the President of the United States rather than the Constitution would be inappropriate.
Or an oath to the President of the United States, period, is not appropriate.
Congressman, you're talking about a hypothetical
Okay.
where it's not clear what was asked or what was said.
You also
as
said,
long as you are following your oath of office, you can also be faithful to the administration.
no, that's not, faithful is not the question. I'll move to a new question. You also said you would not respond to the question to say whether or not the President of the United States had asked you to initiate criminal prosecutions against political adversaries, that you would not disclose whether or not those conversations took place.
I said I would disclose if I was told to do something improper.
Well, what about if you were encouraged to do something improper? What if you were encouraged to initiate a criminal investigation That's not appropriate to do, is it?
Several of your colleagues on both sides have encouraged me today, Congressman, and as I've explained, I'm going to base my decisions on the facts and the law.
I understand that, Mr. Rizzi, but the action of a president to encourage you to initiate a criminal prosecution, separate and apart what you will do with that, that very action is not appropriate.
You're free to make that judgment.
Well, I'm asking you in your judgment, isn't that inappropriate?
My judgment is it would be inappropriate for somebody to order me to do something.
But it wouldn't be inappropriate for your supervisor, the person you serve, the president of the United States, to tell you or suggest you or encourage you to initiate a criminal prosecution against a political adversary?
Congressman, I think I've been very clear about this, that nobody is giving me
I'll just
any
end with this
proper orders.
I'll just end with this, Mr. Deputy Attorney General. You know, we've heard you very proudly here talk about the integrity of the Department of Justice and the work of the FBI. We heard Director Wray say the same thing. These two agencies, the FBI and the Department of Justice, are in the midst of an unprecedented attack by individuals who are trying to undermine the credibility of this independent counsel's investigation. These are the same group of individuals who praised Robert Mueller when he was appointed. Spectacular, was praised uniformly. And now the only thing that's changed is 2 indictments, 2 pleas. Michael Flynn, part of the president's inner circle now, cooperating with the government. That's the only thing that's changed. We need to hear your voice defending the integrity of this department, rule of law, the independence of this investigation, because the very future of our democracy is at stake if you fail to do that. And so I urge you to do so, and with that, I yield back.
The chair recognizes the gentleman from California, Mr. Issa, for 5 minutes.
Thank you. Mr. Deputy Attorney General, if someone comes in to make that complaint or to file that information, they're going to have their identification checked for who they are, right, to get into the building?
I'm not certain if they were to admit it to the building. You actually can walk into most FBI offices, I think, without having to go through security.
But you wouldn't consider it draconian if, while they're filing this complaint or allegation, their driver's license was looked at, would you?
Well, if we're going to conduct an investigation, we need to know who the witnesses are.
Thank you. I just wanted to know that that wasn't draconian. In the case of Mr. Strzok, there was an appearance of impropriety that people are observing, but you'd said, well, there may not have been the reason, but if it wasn't the appearance of impropriety based on his numerous rather strident tweets, or not tweets, but text, commenting adversely on the president, what was it?
If I said that, Congressman, it was inadvertent. The decision to remove Mr. Strzok off that case was made by Director Mueller based upon the circumstances known to him. It's important to understand, though, that those text messages were uncovered in the course of an Inspector General investigation that is not complete, so we won't be able to make any determination about what, if any, discipline is required.
Well, let me go to the Inspector General now. This is Michael Horowitz, right?
Correct.
Michael Horowitz has repeatedly complained that he cannot, in fact, he does not have the authority to look for impropriety by lawyers as to their conduct as lawyers, because the office of the OPR has that authority. That's still true, isn't it?
It's true, but he does have authority for certain types of misconduct by lawyers.
Okay, so we have a situation in which he can look at some of the misconduct, not others. So one of the pieces of misconduct he cannot look at would be the question of bias or the appearance of bias in their investigations, in how they're conducting it, or decisions. That is uniquely excluded to the Inspector General in your cabinet position versus all other cabinet positions.
I'm not certain about that, and if I may, I'll check and get back to you on that. But it would either.
But he is excluded.
It would either be OPR or the Inspector General. And with regard to conflicts of interest, I believe certain of those are within the jurisdiction of the Inspector General, but I'd have to verify.
Okay, well, you can get back to me on that. These political views that Mr. Shabbat mentioned, and they're pretty clear that these are people who had a strong preference. But notwithstanding that, let's be very candid. Nobody up here is going to claim to be without their political bias. So one of the reasons that when there is a a conflict of interest, people recuse themselves, and when there is an appearance of impropriety, they're excused. And one of the reasons that we look to a special prosecutor and that you appointed a special prosecutor was to not only get past the politics on this dais, but to get past the appearance of any conflict by the Department of Justice. Is that fair to say?
To minimize any appearance on either side of bias, correct?
Okay, but a special prosecutor under the remaining statute, how it's done, is still a group looking for wrongdoing. That is their charge. They're not looking for right doing, they're looking for wrongdoing. That's fair to say, like any prosecutor, you're not looking for innocence?
The way I would characterize it, Congressman, is that they're looking for the truth, and then they'll make a determination about whether or not it's appropriate to prosecute.
Okay, so my question to you is, if that's the case, if we accept that, my assumption, that they're looking to, if they can, to hang the president or people around him, hear me out for a moment, then there really isn't a problem with having people that are dead set on trying to find anything that will incriminate the administration in a Russian connection, which is somewhat their charge. So I'll posture to you that maybe it's not that bad to have people who really dislike the president and would like to hang him. Having said that, when there's impropriety, such as Mr. Strzok, when there is, in fact, a history at the FBI of withholding information from Congress, when there is the appearance of impropriety by the Department of Justice, and when the Inspector General is limited under the statute, both because he doesn't have full access and because certain portions are out of it, wouldn't you say that this is a classic example where, in order to investigate the FBI and the Department of Justice, a special prosecutor who is equally looking for the truth, if it exists adversely to the conduct of the FBI and the Department of Justice, is within your charge and responsibility to see that happens?
The time of the gentleman has expired.
You built a number of assumptions
Mr.
into your
Rosenstein may
question,
answer,
Congressman, and my simple answer to it would be that if we believe there was a basis for an investigation or a special counsel, I can assure you that we would act.
Well, Mr. Chairman, I would say that since we've already had dismissals for wrongdoing, since there's ongoing internal investigations, the elements necessary to ask for a special prosecutor to, in fact, see what was done wrong already exist.
I recognize the gentleman from Ohio, Mr. Shabbat, for 5 minutes.
Thank you, Mr. Chairman. Mr. Rosenstein, you already indicated that Mr. Strzok was removed for impropriety. It's beyond me how the other people that were mentioned by the chairman and Mr. Smith were not removed for impropriety as well. Let me ask you, first of all, I assume that the team you put together, you felt was going to be, that Mueller put together was going to be fair and unbiased, correct?
Correct. I selected Mr. Mueller, and
he
made
selected the team.
decisions.
Right. Now, let me just review a few facts about the supposedly unbiased group of people that Mr. Mueller pulled together. 9 of the 16 have made political contributions. To be fair, let's just go through them in alphabetical order. First, Greg Andrus gave $1,000 to the Democrat running to hold the seat, the Senate seat, previously held by Barack Obama. He gave $2,600 to Democrat Senator Gillibrand, who just this week led the charge of Democratic senators demanding that President Trump resign. And oh yeah, Mr. Andrus gave $0 to the Trump campaign, or to any Republican for that matter. Next, again in alphabetical order, Rush Atkinson. He donated to the Clinton campaign last year, again $0 to the Trump campaign. Third, Kelly Freeney contributed to both Obama campaigns and to Hillary Clinton's campaign, $0 to the Trump campaign. Next, Andrew Goldstein. He donated $3,300 to both Obama campaigns, again $0 to the Trump campaign. Fifth, Elizabeth Prelogar, who clerked for liberal Supreme Court Justices Ginsburg and Kagan, contributed to both the Obama and Clinton campaigns, and $0 to Trump. Next, James Quarles. He's contributed to the Democratic presidential campaigns of Dukakis, Kerry, Obama, and Hillary Clinton, and Gore as well. He did contribute to former Congressman Chaffetz and Senator Allen, but he contributed over $20,000 to Democratic House and Senate candidates, and again gave $0 to Trump. Seventh, Jeannie Rhee. She actually represented, as was previously mentioned, Hillary Clinton and the Clinton Foundation In several lawsuits, she's donated $16,000 to Democrats, contributed $5,400 to the Clinton campaign, and $0 to the Trump campaign. Eighth, Brandon Van Grack contributed to Act Blue, the fundraising outfit organized to elect Democratic congressional candidates, contributed to the Obama presidential campaign, and of course, gave nothing to Trump. And finally, Andrew Wiseman, he contributed $2,000 to the Democratic National Committee, $2,300 to the Obama campaign, $2,300 to the Clinton campaign, and $0 to Donald Trump. He's also the guy who praised the holdover acting Attorney General Susan Yates for defying President Trump on the travel ban. Now, my question to you is, how with a straight face can you say that this group of Democrat partisans are unbiased and will give President Trump a fair shake?
Congressman, I think it's important to recognize that when we talk about political affiliation, that all demonstrates political affiliation. The issue of bias is something different. I've discussed this with Director Mueller, and he and I collectively have a lot of experience managing offices in the Department of Justice. We recognize we have employees with political opinions, and it's our responsibility to make sure those opinions do not influence their actions. Pardon me. And so I believe that Director Mueller understands that, and that he is running that office appropriately, recognizing that people have political views, but ensuring that those views are not in any way a factor in how they conduct themselves in office.
Well, when you say he's running it appropriately, I think putting the committee, the people, his investigators together to begin this investigation in the first place is part of the investigation, and how these people, the group he put together, is considered unbiased. I don't know how anyone can possibly reach that conclusion. You know, when this whole Russia was involved in our elections flap surfaced, and you picked Robert Mueller to lead the investigation, I was at first encouraged. It seemed like a serious matter and it deserved a serious investigation. And I assumed, as many of us did, that Mr. Mueller would pull together an unbiased team. But rather than wearing stripes as umpires and referees might wear, I would submit that the Mueller team overwhelmingly ought to be attired with Democratic donkeys on their jerseys, or I'm with Hillary t-shirts, certainly not with let's make America great again. And I think that's a shame, because I think the American people deserve a lot better than the very biased team that they're getting under Robert Mueller. And I think it's really sad. I yield back.
Chair recognizes the gentleman from New York, Mr. Nadler, for 5 minutes.
Thank you. On Monday, Ranking Member Cummings and I wrote you a letter, sir, about the majority's ongoing investigation into the investigation of former Secretary Clinton. Without objection, I ask unanimous consent that our letter be placed into the record.
Without objection, it will be made a part of the record.
Thank you. For the first part of our letter discusses the department's failure to provide the minority with access to the documents you've already provided to the majority. Yes or no, will you commit to ensuring that the minority, that we receive equal access to any materials you may provide to this committee in the future?
Yes, and I believe my understanding is that that information may have been provided to the
I'm
prior
not
ranking
interested in
member.
the past at this point. Thank you. That's what I wanted. I have a lot of questions. The majority of this committee, the White House, and President Trump's private attorneys have all called for the Department of Justice to appoint a new special counsel to investigate a number of Hillary Clinton-related matters. I think we could benefit from your experience in how the special counsel regulations work. The regulations say the Attorney General, or in your case, the Acting Attorney General, will appoint the special counsel when you determine that 1, criminal investigation of a person or matter is warranted, and 2, the investigation either presents a conflict of interest to the department or some other strong public interest requires you to appoint the special counsel. That first part, when he or she determines that criminal investigation of a person or matter is warranted, is that part of the regulations optional?
No, that isn't part of the regulations.
Thank you. So a criminal investigation must first be determined to be warranted before you can assign a special counsel to the matter?
Yes.
Thank you. And at the Department of Justice, a criminal investigation requires an initial assessment and a preliminary review of the evidence?
Correct.
Has that assessment been made with respect to former Director Comey's handling of the Hillary Clinton investigation?
I'm not going to comment on any investigations in the normal course, before we made a determination, we would conduct an appropriate review.
And I assume your answer would be the same if I asked you about the FBI's interaction with Fusion GPS.
Would be the same for anything,
Okay.
yes.
Then presuming for a moment that the department has conducted an initial assessment and found no predicate for a criminal investigation, so in plain English, there is no ongoing criminal investigation. Under this presumption, could you or the Attorney General Sessions simply appoint a special counsel to look into these matters?
No.
As I said earlier, to my knowledge, there's been no credible factual or legal claim that anybody at the department violated any law by deciding not to bring charges or by attempting to meet with Fusion GPS. If that is true, if there is no underlying criminal investigation because there is insufficient evidence of a crime, in this or any other case, do the regulations permit you to appoint a special counsel?
No.
Thank you. According to the department, the Office of the Inspector General informed Special Counsel Mueller of the existence of these text messages between Peter Strzok and Lisa Page on July 27, 2017. The text you sent us last night. Mr. Mueller immediately concluded that Mr. Strzok could no longer participate in the investigation, and he was removed from the team the same day. Did Mr. Mueller take appropriate action in this case?
Yes, he did.
Thank you. In testimony before the Senate Judiciary Committee, you said that you would only fire Special Counsel Mueller for good cause, and that you had not seen any yet. Several months have passed since then. Have you seen good cause to fire Special Counsel Mueller?
No.
Thank you. If you were ordered today to fire Mr. Mueller, what would you do?
As I've explained previously, I would follow the regulation. If there were good cause, I would act. If there were no good cause, I would not.
And you've seen no good cause so far?
Correct.
Thank you. On May 1st, the Office of Legal Counsel issued an opinion arguing that ranking minority members do not have the authority to conduct oversight, unquote. Shortly thereafter, Politico reported that the White House counsel instructed federal agencies not to cooperate with oversight requests from Democrats. Since then, Democrats on this committee have written more than 40 letters to the administration without any meaningful response thus far. Can you clarify your current position on responding to letters from the minority? And are you concerned that the department's May 1st opinion serves to justify a policy of stonewalling by the administration?
My position, Congressman, is that we make every effort to respond to any legitimate inquiry from a member of Congress. Obviously, we prioritize inquiries propounded by the chair on behalf of the committee, but we'll make an effort to respond to any inquiry. We get a lot of letters.
I'm sure.
And so I apologize if there's a
But would you
delay, but
prioritize after letters from the chair, letters from the minority?
Our goal is to respond to all those letters in a reasonable manner. In fact, when our new Assistant Attorney General, Stephen Boyd, took office, there was quite a backlog.
And would you encourage the Office of Legal Counsel to withdraw its May 1st opinion?
I'll take a look at it, Congressman, but as I said, without regard to what the law may require, our policy is to try to
I understand that,
accommodate any
but
requests.
you would take a look at whether you would encourage the Office of Legal Counsel to withdraw that May 1st opinion.
Well, I'm not committing to do anything. I will agree to look at it.
Okay, thank you. And finally, I just want to say and follow up with what the chairman was saying about Section 702. The bill that this committee reported specifically said where you're doing a counterintelligence or foreign or terrorism investigation, you don't need a warrant to query Section 702 data. But where you're conducting an investigation of domestic crimes, then, like any other investigation of domestic crimes, you would need a warrant. So that the danger that I think you were referring to is taken care of by the bill, and I endorse the comment of the chairman to that effect, and I think you should take a look at that. I urge you to take a look at that. Thank you. I yield back.